Belgium has historically maintained a highly favorable tax framework for creators. However, recent legislative overhauls have aggressively tightened the rules governing how copyright income is taxed. As the 2026 framework takes effect, these benefits are no longer a broad entitlement. The state has restricted access to a much narrower group of professionals. Qualifying for this regime now requires passing a rigid 3-step administrative test. This sequence acts as a filter, designed to identify and remove insufficient claims immediately. These requirements are entirely cumulative. If a claim fails even one stage, the application is void. There is no middle ground. Obtaining these tax advantages has shifted from a routine administrative task to a high-stakes test of total legal precision. The first hurdle is the civil foundation. Before the tax code even applies, you must prove you have created a genuinely original work. This ruling from the European Court of Justice establishes the standard. A work is only legally original if it reflects the author's own intellectual creation. Repetitive technical routines, general consulting, and project management tasks are specifically excluded. Beyond the creation itself, the law requires a formal written contract. You must be able to produce a signed assignment or license that transfers the rights to that specific work to a third party. Moving to the second hurdle, the financial link. The law requires you to isolate copyright income from standard professional fees. Compensation must stem exclusively from the transfer of creative rights, rejecting general administrative labor or uncertified service time. Even a masterpiece provides no tax benefit if your financial records and contracts fail to explicitly link the payment to the creation itself. Once the work and the finances are documented, you reach the final hurdle. Eligibility at this stage is restricted to 2 specific paths. The first path requires a professional certification. The creator must hold a valid arts worker certificate, or attestation du travail des arts. For those without this certificate, including many in the software and IT sectors, there is only one alternative. You must prove the work is definitively intended for public communication, representation, or reproduction by a third party. This creates a significant barrier for internal projects. If the software or design is used solely for a client's private internal operations, the second path remains closed, and the claim is rejected. A perfectly drafted contract will still fail the final assessment if you cannot prove the work's ultimate destination is professional or public. The 2026 landscape is defined by rigorous administrative oversight. Every element of a submission is now cross-examined for any sign of inconsistency. Success here depends on absolute coherence. Your legal contract, creative output, and financial accounting must perfectly align. A single discrepancy collapses the file. If an invoice description deviates from the contract, expect a full administrative rejection. Establishing this level of precision across all documentation is the only reliable way to protect your work and your income under the new rules. Navigating this framework requires strict compliance. This analysis provides legal information on the current regime, not tailored legal advice for individual situations.